Welcome back to our podcast series, Advice from Your Advocates. I'm Bob Manner, a certified elder law attorney in Michigan, and this podcast is designed for those that are interested in long-term care issues and anything related to seniors. Today, we have a very special guest that's going to talk about service-connected disability claims with the Veterans Administration. So we have Britney McDonald from Marc Whitehead Associates in Houston, Texas.
Hi there.
Britney, can you tell us a little bit about what you do and what your position is at Marc Whitehead Associates?
Well, I'm a managing attorney at the firm, and I manage about 45 paralegals here and there in our various departments who fight for different types of disability claims. So that's Social Security, VA, employee and private disability insurance, things that are covered by ERISA, privately purchased plans. So it ranges from disability benefits, like our name says, it's kind of a catch-all term, all the way down to life insurance and some health insurance claims, 401k disputes, things like that.
I'll give the listeners a preview. We're going to actually be interviewing Marc Whitehead in a little bit in a future podcast, and we're going to focus on that will be related to insurance-related disability claims. Today, the focus is going to be on veterans-related disability claims. So tell us a little bit about what is you can use the terminology and explain it for us. What is a disability claim or a compensation claim through the VA?
Really, a disability claim through the VA is just a claim that something happened to you in service or something that you experienced led to a disease or an injury that you're suffering from now. And under the VA regulations, it's payable. They should be paying you a monthly benefit. So it's a way for you to get compensated for your service for anything that happened to you during service.
And I want to say this right at the beginning of the presentation. If there's any idea that you might have a service-connected condition, apply, even if you get denied. And so I have so many folks that have come to see me that said back in the 80s that they applied or they went to the VA because they thought they had a service-connected issue with regard to their service, and they were told by someone, whether it was the VA or a service officer or somebody like that, that told, oh, the VA doesn't cover that condition, so there's no point in applying. My advice is apply, even if you get denied. They may determine later that it is a service-connected condition or tied into some chemicals that you might have been exposed to or something like that. And that's the only way, I believe, typically, that you're going to be able to go retroactive is if you've actually filed a claim. Am I right on that, Britney?
Yes, that is true. That is accurate. Yeah.
So I encourage everybody, if you got a claim that you think, and so cancer, anything like that, especially if you did serve in an area that you might have been exposed to different things, it's best to apply. And then if later on they determine that it is connected or that it's something that we're going to talk about called a presumptive condition, that you might be able to go backwards. I had one of my close friends, his father applied when he was about 90 years old, got benefits, got 100% service-connected disability, which is a significant benefit. But the reality is he should have applied 20 years earlier. And so that's just apply, even if you get denied, it's that will be in the record. And if later on we determine that it's relevant, then you might be able to go retroactive for benefits.
Sure. Yeah.
So break this down for us. What is, give us some examples of what just generically, and then we'll talk about some of the specifics. What are the typical service-connected claims that you might see?
Well, really anything can be service connected. There are limited conditions that can be presumptively service connected, but obviously, just general service connection claims are wide. Those come to us all the time. If, for example, let's say you were a paratrooper and you landed wrong, you had an injury to your knees or your back. And if if you went and saw somebody during service, or there's some record of that landing and the injury that you had, in general, you should be able years later, if you have your departure from service and then you continue to treat for the problem that you suffered, years later, if you file a claim for service connection, you should be able to relate it back to that incident. And so there are really two ways to do that for service connection. You need three elements. And so you would say, first of all, the incident that happened, the incident or the injury that happened in service. And then you have to have a currently diagnosed condition. And then you have to have a link between the two that the VA calls a nexus. And so there are two ways really to get a nexus. There's continuation of symptomatology, continuity of symptomatology, where you treat for that condition continuously, really, until you file. And so there's no question that it's the same condition, it's related, or you can really just have the two, the service issue and the current condition, and then have medical literature and a doctor opine that due to the circumstances, it's related. But either way, you need those three things to get a claim granted.
Oh, that's very interesting. And I know we're going to talk about presumptive conditions in a second, but before we go on to that, what about things like PTSD, which how are we going to provide evidence on something like PTSD?
Well, and that's a great question. I think all of the VA claims kind of come down to that. How are we going to find evidence? Because there's a lot of things that are lost in time, whether they were records lost to a fire, or nobody documented something, or like PTSD, it's something that's latent for a lot of individuals. It happens much later in life, or they don't realize what's happening. So in that particular case, really for PTSD, there are certain presumptions that you can get if you're a combat veteran. They presume that if, your stressor statement, which you'll have to provide the VA about what happened, if your stressor statement matches the circumstances under which you served, they're generally not going to question it unless there's directly rebuttable information. So if you say something happened during combat, you did something traumatic, or you witnessed something traumatic, if you say that happened, they're going to presume it's true. And then as long as you have ultimately a diagnosis of PTSD under the DSM-5, and generally that actually has to be made by the VA as well, not just a private provider, they'll send you to a compensation and pension exam to verify that. So as long as you have a combat presumptive stressor, and then you have a current condition, they're going to give you that nexus between the two. But that's distinguished from other mental health conditions, because PTSD is really the only condition that you can get without continuity of symptomatology through time.
Okay.
Yeah. And so for example, if you have, let's say, depression, to get service connected for depression, you actually have to have had symptoms and treated for, or have something in your records that signify that you had depression back in service, and you had to continually be able to prove that that was something that you had connected to your currently diagnosed depression. So it is a little bit different. But also, just because you mentioned it, sometimes these PTSD claims, sometimes you're not a combat veteran. Sometimes you have other types of PTSD, for example, military sexual trauma. We have a lot of clients that have dealt with things like that, and obviously just as, if not more, traumatic at times. And so that can be hard to pinpoint, because a lot of people are not forthcoming with that information for obvious reasons.
Right.
And so you look back at somebody's personnel records and you find markers in service to show that, yes, they were suffering from some traumatic event, even though they didn't tell anybody. It's PTSD. It should still count. And so we work really hard to find ways to develop evidence so that the veteran can still prove up their service connection to the VA.
So when it comes to evidence, as you said a minute ago, that you do have to have the VA doctor, make an examination. And so I've talked to some veterans that have applied, and they didn't really agree with the VA doctor's analysis. Do they have to be stuck with that? Can we present other evidence beyond that one exam by a VA doctor? How do we deal with that if we have a VA doctor that does not support the claim?
Yeah, I mean, certainly I don't talk to every veteran who's had a compensation and pension exam, but on the whole, most veterans disagree with the way the exam goes down. The doctors are rushed. Sometimes they're apathetic. Not to say that they don't mean well, but I think veterans are going through an experience and they expect a particular level of care, and sometimes it doesn't meet what they expect. So if they disagree with what the doctor says or does or their ultimate opinion, they have every right to go out and talk to their own doctors, get their own opinions. And the unfortunate side about that is that the VA, specifically, a lot of veterans treat through the VA, and the VA doctors, the ones that work at the VAMC, have many times been instructed that they can't get involved with opinions about service connection, that's up to the compensation and pension examiners. And so what we always tell our veterans is, first of all, it's worth a shot to ask. Even if they tell you that they can't do it, you should talk to them about it. And if they can't write an opinion outright in your records and say there's a nexus here, maybe they can put it in their medical records. And we've had a lot of veterans who've had that happen, where the doctors will say something in the medical records as opposed to on a nexus statement form, where they believe, this is related to service, whatever that condition may be. So they can also get other doctors, private providers, to write it. There are, resources nowadays, especially in the last 5 years. Medical providers who are familiar with VA regulations will review C-files and will review current medical treatment records and stressor statements and whatever the condition may be, the information about that. Usually they typically specialize in whatever that veteran is claiming, and they will write, for a fee, of course, they will write a nexus letter for you if they believe that it should be service connected, if they believe in the opinion. So if worse comes to worse, there are always companies that will do a review for you and can help you, can assist you with that. There are a lot of companies that do that now. But really, anything that you present in the form of an opinion, if it's a good opinion, if it's a reasoned opinion, it's supposed to stand up to the VA's opinions. And because the VA is supposed to grant the veteran the benefit of the doubt, if you have an opinion and they have an opinion, they're supposed to look at it as equipoise and grant favor to the veteran. And obviously that's not always that's just not always what happens, but we have ways to fight that. And that's obviously, something that an attorney can help you with, to fight the VA's actions when they've made a wrong decision based on the evidence in front of them.
You mentioned something a second ago, and I want you to clarify what you said. C-file. What's a C-file? So
a C-file is really, think of it like a claims folder. It's basically all of the documents from the beginning of service, including your entrance exam, down to everything, every letter that the VA has sent you, every, communication that they've sent internally about you. It's really just everything that spans your career in service and after service related to any claims you have, and including your VA healthcare, because your VAMC records will go into that as well. If you want private treatment records in there, you have to submit those, but of course those can be in. You can really put anything in it. And you really only put the information in after your discharge if it's related to a claim, if you think it's going to assist you with filing for service connection or an increase or some other entitlement.
Speaking of files, we've worked with, in my office, a lot of World War II veterans and their surviving spouses, and Korean War veterans and their surviving spouses. And one of the common things that we hear is, we lost the DD-214. We've contacted the VA. They say they lost it in the fire in 1971. What do we do if they can't find their DD-214?
Well, what we do is we get as much other evidence as we can find. I mean, that's a common problem. I think every VA attorney has heard that too many times. You get as much information. You can submit pictures, if you have pictures of the veteran. We've certainly done that before. We always, the VA has ways to search other records that they have, even if they don't specifically have the DD-214. There are various types of forms that would document where they may have been under different conditions. Sometimes, if somebody's been, for example, to Vietnam, there was a letter that went out to acknowledge the fact that they were going to Vietnam or that they'd been there. So there are different ways that you can piece together information to prove up the fact that you were located somewhere or that you served under a certain capacity.
So on the DD-214, if you're not familiar with the terminology, that's the discharge paper that you're generally going to get if you were in active duty and sometimes in reserves. So one of the things, just as an aside, and this is true not just for when we're dealing with a VA claim, but any kind of government benefit where they're evaluating your physical condition or anything else. I always tell my clients, that, and you're going to find this funny, Brittany, but I wouldn't be surprised if you say the same thing, to be a little grumpy on the day that they do the evaluation,
Sure.
because so many people, and I think this is very common, especially with veterans, especially with older veterans, where they're proud, they're stoic, and you say, how are you doing? I'm doing just fine. Can you get up out of bed on your own? Yes. Can I get dressed on my own? Yes. Can you shower on your own? Yes. Well, that's not true. You need help with all those things, but because of pride and stoicism and just their personality, that it's hard for them to, they're just being polite, kind of a thing. And so I always tell people, as an aside, if you're ever in that situation, whether it be veterans benefits or Medicaid or any kind of home care benefit, anything like that, you got to be a little grumpy the day that they do the examination.
Absolutely true. We find a number of veterans just they don't want to burden people with their problems. And aside from the stoic, older, I'm fine, I'm a tough man, I was in the military and nothing's going to harm me. And if it does, you're not going to know about it mentality. We always just tell them, you have to be honest, you have to be real. They're not going to know what you're going through unless you tell them. And they're not going to infer that you're going through it unless you speak it. So you're absolutely right. And that's certainly advice we give every day. Yeah.
So let's shift gears a little bit and talk about one of the big topics that I think people need to understand, and that is this thing called presumptive condition. So explain that to us, how that's relevant and why that would be of interest to a lot of folks, especially that served in Vietnam or later.
Yeah, so there are various ways to get service connected. There's, direct and secondary, and then the big one that you're talking about is presumptive. And so presumptive means that they're going to presume that what you went through is service connected without all three elements there. And so earlier I mentioned presumptive for combat. There are other types of presumptive service connection, for example, tactical herbicides for Agent Orange. That's something we deal honestly mostly with for presumptive service connection. So in the Vietnam War, they used tactical herbicides to clear fields. And unfortunately, they didn't maybe know it at the exact time, but they soon figured out that those herbicides were poisonous and causing different conditions, different problems and diseases that the people that were exposed to them, even, there's not even a time length. It's not like Camp Lejeune where you had to be there for 30 days. This is something where if you were there and exposed to it, that's enough to get service connection under presumptive means. So basically what it says is if you have for example, under Agent Orange presumptive service connection, if you have a particular condition that is known to be caused by Agent Orange, if you have that condition and you served in a location that's conceded to have used or been exposed to Agent Orange, and they're just going to presume that you should be service connected. They're going to presume it without you having to prove continuous treatment and that you maybe directly touched it. So we have a lot of veterans who can absolutely say, yes, I rolled a drum of Agent Orange out of a plane, of a C-123 plane. And that's great that they can remember that. And I'm sure that in some way, helps their claim, but they don't even need to say that for presumptive. If they worked on that plane that had it, and that's conceded, and it is in general, where they were in a location like Vietnam or Korea, or the DMZ or the Royal Thai Air Force Base, or various other ones that were recently added by the PACT Act, they presume that you were exposed without you having to talk about you directly touching it, smelling it, or tasting it. And so it's a lot easier for them to get. And the other reason that's a big deal is because there's just not proof, that these people did touch it or tasted it or smelt it. I mean, these individuals are much older than they used to be before the presumptive service connection covered as many conditions as it did. And the laws have become a little bit more friendly to the veterans. And so it's a really big thing to not force them to jump through as many hoops to prove that they, that their cancer is related to their combat in Vietnam.
So let me see if I'm saying this correctly. There's kind of almost two presumptions there, that if you were in certain areas that there's a presumption that you were exposed. You don't have to prove the exposure. And secondly, there's a presumption that if you have the illness that's connected to that you have that causal link, that exposure that you presume to have had caused the condition that you have.
That's right. Yeah, there's two presumptions that basically have to be true to get presumptive service connection. Now, you can still prove, we have a number of veterans who served in areas where Agent Orange is not conceded to have been. We have plenty of veterans who have done that. We've dealt with that many, many times. For example, over in Japan, they don't agree that it's been over there, but we have veterans who have gotten service connected because they did have to go the direct route instead of the presumptive route. So they had to provide evidence that they were exposed to Agent Orange and that their condition is one of the presumptive service connection for Agent Orange. And on the flip side of that, we've had a lot of people who maybe they absolutely served in one of the conceded locations where Agent Orange was used, but maybe their condition isn't on the list for presumptive conditions. And so then their job is to really get evidence, medical evidence, find a doctor who will review it, find research studies to show that Agent Orange did cause their condition. And so they can get direct service connection that way. But again, they jump through a few more hoops to do it. It's a little bit harder.
And I'm not sure if I know the answer to this. Is it possible? And the reason I don't know the answer to this is I'm not sure if it was ever in the United States, but it's possible somebody could have never left the United States and had exposure to Agent Orange. Just dealing, is that possible, or was Agent Orange produced somewhere else?
No, it's absolutely possible. It definitely has been here. There are various locations where Agent Orange was certainly here in the United States, and we've had a lot of those claims as well over the years. But much less common, certainly, but absolutely, that is something that the VA actually now acknowledges. And you can find there's so many locations now. You can find those locations if you were there, if you suspect you've been there. You just get online and go to the VA's website and you can type it in and they'll let you know if they're considering exposure to be conceded in that area.
Oh, wow.
Yeah.
Well, and that's one of the other things that we try to keep an eye on is the sort of seemingly every few years adding additional diseases that are considered presumed conditions. And so one of the ones that we keep an eye on, so many cancers. I mean, I can't even read the list. I have a couple of pages full of presumed conditions that were tied to Agent Orange. But some of the big ones for us that I'm seeing in my clientele is Parkinson's, Parkinsonism, so many different types of cancers, ischemic heart disease. I think there's a type of diabetes that has been tied to Agent Orange.
Yeah, that's right. Yeah, type 2 diabetes and peripheral neuropathy. There's a laundry list of cancers now, honestly. And, like you said, Parkinsonism, that's a big one that we see a lot for. Diabetes, ischemic heart disease, what was I going to say, colorectal. There's so many. Cancer-wise, probably the most common one we see, especially for men, is prostate cancer. That's pretty common anyway. And I mean, honestly, we have a number of individuals who have Agent Orange exposure who have multiple Agent Orange conditions, including prostate cancer. That's kind of like one of the default for men. But yeah, bladder cancer, even respiratory cancers like lung cancers are included. Yeah.
We have a number of different audiences that listen to this podcast, and some folks are probably tuned in just because they are curious and interested in the veterans benefits. I know a lot of our listeners are involved in the long-term care industry and dealing with seniors. I've been telling other elder law attorneys for the last 10 years that the next big wave of seniors is going to be those Vietnam veteran seniors that are aging into our population. So historically, we were focused on the World War II generation and the Korean War generation. And so in the last few years, we're seeing more and more veterans of Vietnam era that are coming in and needing long-term care services. And as an elder law attorney, we're often looking at things like Medicaid and Medicare and other community-based services, things like that. But you really need to keep an eye out, and this goes out to the social workers and everybody else that might be listening. keep an eye out for a veteran, especially if they served in Vietnam or around Vietnam or in Korea and the DMZ, or DMV, I'm sorry, no, DMZ, demilitarized zone. All right, sorry. Thank you. And so, but keep an eye out for that, because there are significant benefits that could be a game changer for these families. And, I know sometimes, especially lawyers, often will look towards Medicaid or those types of services. But if veterans benefits plan can be more flexible. Is it hard to deal with the VA sometimes? But that's why we have folks like Brittany that can help us get through that bureaucracy of the VA.
Yeah, no, that's absolutely true. We do have a long-term care department here, and we have some veterans that are in it, and so we always try and point them to as many of the resources that we can, that we're knowledgeable about, the ones that we use, and try and provide them with any means of help. Obviously, when you're older, when your family member's older, you need as much help as you can get, and honestly, nobody believes that veterans don't deserve it. They gave their life, they gave so much of their bodies and their energy to serve our country. And that's why I'm doing this. They're entitled, and you want to just provide them with whatever they can get. And there are a lot of resources that people don't know about until they really talk to attorneys or really talk to, different organizations that help veterans. So I'm glad people like you are around to help point them to those too.
Yeah. And that's, if you're in Michigan, give us a call. We can help you get connected with the right folks. I will tell you, I mentioned earlier, Brittany's in Houston, Texas. And the thing about that is, the nice thing about veterans benefits is that it is national. It is not based on state law. And so we don't have to, I refer folks to Brittany and Marc Whitehead and Associates, and including my father-in-law and several friends of mine and their families. And the idea is, when it comes to these things, it's about working through that bureaucracy of the VA and making sure you have an efficient process. And I think that's one of your best expertise in your firm is to have a process and procedure to be efficient about pushing these through the system.
That's absolutely right. And, the VA does have a long, convoluted system. They've changed it over the years. We now refer to the old system when I started as the legacy system. Now they've got, as you know, the AMA, the newer one, which kind of changes up lanes and ways to get your file reviewed. And while we do everything we can to speed it along, one of the most important things that a veterans attorney can do is make sure that it's right the first time. So you don't get pushed back, because these claims can go on for decades, just circling different rounds. And if you don't have everything in place, if you don't have the right strategy for your claim at the very beginning of it, you can find yourself dealing with this 10 years later. And we have clients like that have been dealing with this for a long time, that have come to us after the fact trying to get some help.
And just to kind of put a fine point on that, because of the efficiency of your office, no one ever has to fly into Houston or come into your office or anything like that, right? Everything can be done through remotely and through the internet or mail and things like that, right?
That's right. Yeah, that's right. We have clients, that live everywhere. We have clients, down in Puerto Rico. Basically, a lot of the areas in our firm practice under federal law. And so if we need to see clients face to face, it's wonderful if we get to fly out to see them, or if there's some chance where we get to do that. But most of the time it's over Zoom or just a phone call. And really, that's oftentimes better. Clients don't like coming to the office when they're suffering from disabilities. We can often go to court over Zoom or through the telephone, things like that. I do a lot of BVA hearings over the VA's version of Zoom.
Now, I'm thinking back that there's a couple things that we didn't talk about, I think is important. We talked about being in Vietnam and the DMZ and Korea, but talk about blue water and brown water and what those mean and how that's important for folks that may have been told that they can't apply or shouldn't apply before.
So name or claims. So basically, I may have mentioned this, I'm not sure, but back when I started, there were a lot of conditions that were not presumptively linked to Agent Orange, and a lot of locations that were not presumptively linked. And so they were, just rubber stamped with a denial. And so, as you mentioned, Robert, earlier, it's really important, if you think that you were exposed, even if you don't have everything, all of your ducks in a row, or you don't have necessarily a presumptive condition or location, it's important to file that claim, because new things are being added to the presumptive list all the time. And if you have that claim, you can get that claim opened up later on when those conditions become presumptive, or if you, later find scientific medical evidence that will prove that you were exposed or prove that what you're saying is legitimate. And so for those types of claims, for example, for the longest time, to get Agent Orange exposure in Vietnam, you had to have boots on ground. Then they approved brown water because they said, obviously in the inland waterways of Vietnam, there was probably some exposure. And so for years, we had blue water veterans. That's what we call veterans who were serving on ships just outside of Vietnam and Cambodia. And so these veterans that served on these naval vessels or the Air Force and flew in or whatever it was that they were doing, they were coming down with Agent Orange conditions and diseases and filing claims, and were not getting granted. And we had a number of them early on in my career that were denied, that after the blue water veterans were eventually approved, the VA took their claim, they took it back and reviewed it and granted them. And so the VA made some changes to the law to where these blue water veterans, if they were within 12 nautical miles of the demarcation line of Cambodia and Vietnam, that if that was an Agent Orange conceded area. And so if they came down with the conceded presumptive disease, then they could file and get presumptive service connection. And so, as you mentioned, and what I'm saying is always file. If you think there's a chance that you were exposed, if you believe you were exposed, if you saw it, but you can't prove it under the current law, it may change. Things may change, and you may be able to prove it. And even the VA, without the help of an attorney, sometimes will take your claim back and re-review it under the more current regulations.
So there's been some recent development in this area, some legislation that recently passed federally, and you've mentioned it a couple of times. I'd like you to give us a little bit more detail about the PACT Act, P-A-C-T Act, and how that relates and how that has expanded some of the things that we've just talked about.
Well, the PACT Act is a new act that was recently signed just at the end of the summer by the president, which has just been something that VA attorneys are celebrating. Lots of attorneys are celebrating. Lots of veterans are celebrating, because our clients, they're finally getting to see expansion of the presumptive conditions and the locations. And so in general, the PACT Act actually covers a lot of different things under toxic exposure. So one of the things that our firm has been heavily involved with has been Camp Lejeune with the toxic water, the contaminated water supply, and obviously burn pit exposure. So all of, fumes from burn pits have a lot of, I think there are 23 conditions that are presumptively linked to burn pits now. This is all under the PACT Act, that and Camp Lejeune. But under Agent Orange specifically, this is a huge win for veterans and for the people that help them, because now they have expanded the location. They've acknowledged that various other locations that they, for a long, long time, just denied, had Agent Orange. They're saying, we agree, you can file a claim now and we'll review it. So it's a pretty big deal. You mentioned earlier about areas in the U.S. Absolutely, areas in the U.S., different areas overseas as well. Lots of different areas. I have a long list of them somewhere on my computer that we just reference all the time when we have an intake, a veteran call in, and they say, I was in so-and-so, could I have been exposed to Agent Orange because I've got one of the conditions? A lot of the people that are calling in were finding that they were, that the VA is finally recognizing some of these areas that caused it. Yeah.
So then if you were in the military, what would you say, time frame of, say, late 50s up until now, and you have a cancer or one of these other, sort of dreaded diseases, it's probably worth looking into to
Definitely.
see if you served in one of those areas.
Definitely. Yeah, definitely. Lots of different areas in the U.S., lots of different camps. One of the things that we've been fighting for a really long time in terms of the areas were people who, for example, in Thailand at the Royal Thai Air Force Base, We used to get denials all the time if you were in Thailand and you weren't particularly at the Royal Thai Air Force Base. There are other locations in Thailand where, people were exposed, and the VA is recognizing those. And the same thing in Korea. So,
Okay.
Yeah, Vietnam's always pretty much just been conceded. The whole country was covered in Agent Orange by us. And so if you were there, you can pretty much get it. You just have to have some proof that you were there. That's really the only hurdle people jump through.
So Brittany, is there anything else that you'd like our listeners to know about or hear? And what would be the best way to get a review by your firm?
Well, you can certainly call us. And we have a large group of individuals who are ready to talk with you about your claims. I'm certainly ready, and I take a lot of claims personally, but I'll just get on the phone and ask you about them, especially some of the more complex ones. People have a lot of questions. They need legal advice. We provide free consults for things like that. We want to be able to talk with you and help you if you can. Help as many people as we can. We actually have a lot of attorneys here that do veterans law. I'm obviously a CA, Court of Appeals for Veterans Claims accredited attorney, but all of the other attorneys in my firm are as well. So it's not just me.
So excellent. And so do you have that phone number handy just in case somebody has and they're looking to write that down?
Yeah, we've got 713-288-8888.
Well, thanks, Brittany. This was very valuable information. I hope that people really listen carefully to this, because it's going to help so many people, and a lot of people that really never thought about filing claims, and now they're facing some serious illness, and this could really make a huge difference in their family and their ability to support their spouse and support themselves and get the care that they need. So I do want to remind everybody that we do have our upcoming annual boot camp for social workers, nursing home administrators, and case managers. And we offer 5 continuing education credits for those folks in the long-term care industry, or anyone else in the long-term care industry. This is designed for other professionals in the long-term care industry. And that is next year, which is 2023. If you're listening in 2023, then it's this year, but it's Friday, April 21st, 2023. And we're offering 5 continuing education credits for social workers, nursing home administrators, and case managers. So thanks again, Brittany, and we will see all of you, or hear from all of you, and looking forward to the next advice from your advocates.
Thank you, Robert. Thank you so much for having me. It's great to speak with everybody and all the listeners, and I truly just hope that you find somebody, if not us, somebody to help you with these claims, because they're legitimate. So go after them.
Thank you.
Yeah.